Do you have something?
No, not yet. Wait,
okay.
I'm putting everyone in now.
Oh, sorry, can't do it that way.
Hello, everyone. Today is February 3rd, Thursday. It is the convening of the Tax Review Board today. We have real estate on the docket. It is a public hearing. However, please be aware that this public meeting is being recorded and it will be uploaded to our website. Because this meeting is public, participants and viewers have no reasonable expectation of privacy by continuing to be in this meeting. You are consenting to being recorded. That is something I have to say. At this point, I'll give it over to Nancy.
Okay, thank you. The Tax Review Board hearings for February 3rd, 2022 will come to order. The first item on our agenda, and we're taking these in part in the order in which they appeared, if they're in person or we're ready for a virtual hearing. And the first item is item number 2, Elliot Harrigan. Last 4 digits of the docket, 4778.
He's in the room.
I see we have the petitioner in the room. I'll give you a moment to get settled in. And I will, I was just going to say, if you're comfortable to take off the mask, we would appreciate that because we know we'll hear you a little better that way.
Okay.
Please identify yourself for the record.
My name is Elliot Harrigan.
Do you swear or affirm to tell the truth with everything that comes before the board?
I do.
Okay, and I failed to introduce myself. I'm the chair of the board, Nancy Kammerdiener. Who has this matter for the city?
I do. Lawrence Rillo for the city of Philadelphia.
Do you swear or affirm to, oh, you don't need to be sworn in. My apologies. Do you have anyone with you who needs to be sworn in?
There should be a representative from the Department of Revenue.
She's here. Marge Dillon is here.
Can you identify yourself, whoever's there from Revenue?
It's Marge Dillon, Nancy.
Okay. Oh, hi, I wasn't sure. Do you swear or affirm to tell the truth with everything that comes before the board?
Yes, I do.
Do you have numbers for the record for us on this matter?
Yes, I do. Okay, we have for property taxes for years 2015 through 2021. Total principal, $11,194.43. Interest, $3,647.83. Penalty, $1,042.46. Liens and legal fees, $1,694.34, totaling $18,289.06.
Okay. Does the city have any opening comments before we turn to the petitioner? I'm referring now to the city's attorney. No? Okay, then let us turn to the petitioner. Please tell us why you're here and what it is you're looking for from this board.
Yes, I'm here because I've been going through some very difficult times financially. The building suffered some damage from a couple of storms that have taken place, and right now we're not able to do anything with it. I did get some, just a little money from the insurance, but it wasn't nearly enough to be able to make the repairs. I'm also on Social Security. My, for example, for 2020, my gross, adjusted gross income between my wife and myself was only $15,969 for the year 2020. We also have 2 children. So it was very difficult for me to, at least for the past few years, to be able to make those payments. And I'm asking, just asking, of course, I'm senior citizen, I'm 76 years old. I'm asking for some grace in this particular time. By next year, of course, my financial situation will increase and I'll be able to I'm in a position where I can make the agreement on the remaining amount, and I'll be able to pay it going forward.
Will any board
sir,
members
this is
have
Ryan
questions for
Boyer.
the-
I'm sorry.
Go ahead, Hagar.
This is Ryan Boyer, board member. Is this your primary residence?
No, it is not. It is one of trying to just start a little business of a rental property. That's what it is. But they have not been able to do anything with it for a couple of years now.
This, I believe the petitioner was in front of the TRB back in September of 21. And there was a ruling that they abated 50% of the interest and penalties and gave the petitioner 60 days to get into an agreement. No action was taken and no payments have been made. So the city would object to another chance for.
Was that a matter that was taken before the full board, or was that a master's hearing?
I believe if.
It was master's hearing.
It was a
Ms.
master's
Dillon
hearing.
could, yeah.
Okay,
could pull
so that
it.
doesn't negate our ability to look at anything from that time period. If it was the master's hearing that was appealed to the full board. That's why I was questioning it.
Yes, agreed, but I just think that there's been no good faith to do any kind of payment plan or these taxes.
May I say?
However, the board looks at it from the standpoint that if the petitioner has appealed to the full board, they're generally waiting to hear what the full board is going to agree to before entering into an agreement that would negate their ability to come to the full board.
Yes.
So we're looking at this from a different perspective when we hear that it was a master's hearing as opposed to a full board hearing that was not adhered to. Are there any other questions from board members?
Yes. Dominique Ward, tax review board member. When did you acquire this property?
When did I acquire it?
Mhm.
Well, I acquired a property back in 1982, but the property has been used exclusively as a church. It was never used for anything else but a church. It was, of course, we were looking into getting it turned over to the church at one point, and it didn't happen. But that property has never been used for any other purpose for church, and also for a place for the community to have meetings. I've been the president of the community organization for about 15, 20 years now. And so that's what it has been used for.
Okay, and the church is paying you rent during that time period?
Well, I'm a minister myself, so we were not able to collect any rent when I was using the building for that purpose. And of course, when there were any rents paid, it was just enough to be able to. It was a small church. It was just enough to be able to take care of the expenses at the time.
So you did receive rental income for the property?
Well, I was able to receive, well, we didn't call it rent, it was a donation to the building.
Okay, and so you said you received some insurance proceeds for damage. When did you receive those proceeds?
Received those proceeds about 4 months, let me see, 3-4 months ago. The roof was damaged. We had a lot of damage on the flooring. And so they really said that it wasn't so much of a wind damage, because they were just covering whatever the wind did. But it was that some of the roof itself was old and needed to be repaired. So it came back on me to do it.
Okay, so you gave your financials for 2020. What happened in the years of 2015, 16, 17, 18, and 19?
Well, I have all my taxes for those years. I mean, we want the income didn't really change much during that time.
So you're saying you were unable to pay from 2015, 16, 17, 18,
But
and
I
19?
paid some, was not able to pay
Okay.
that amount.
for
To the point that was made earlier, I did not make any payment after the master's ruling, because as the honor has said, I had to immediately went into making the appeal.
No, you're fine. If it's under appeal, it's okay. I'm not looking at you detrimentally for that. Thank you.
During the years,
Go ahead, Ron.
I'll wait till we go in our huddle. I have a question to the rest. Melissa, I have a question for you when we huddle.
Right,
Nate,
Paula,
go ahead,
I have
Paula.
a question for the petitioner. You said that there was property damage from wind or a storm to the property. When did that occur?
Oh, that was the last storm. I think it happened the storm was in August,
Of 2021,
2020.
2020?
Yeah.
Excuse me
Yeah,
for
we don't know.
kind of chuckling. I think I had wind damage that took down a tree that landed on my house from that very same storm, so I can
Exactly.
empathize.
That's the one.
And when did the church stop paying expenses or making a donation?
Well, that was we had not been able to the building. Let's see, that was back maybe about 4 years ago. Because right now we're not using the building for that because we're going mostly virtual. And we can't use it because of the damage, the current damage. So I'd say about 4 or 5 years ago. Yeah, because the membership dropped off tremendously at that point.
Okay, thank you.
Any other questions from the board? Anything that the city wants to present? Or any questions that they have for the petitioner?
The city would just note its objection to anything different than the 50% interest and penalty from the master's hearing.
Can the city tell us when the last payments were actually made on this account? March.
Okay, I can't get into tips right now for some reason that they're
Um,
thinking this computer has no access.
If you would just
I can tell you.
2 minutes, I could log in onto my computer and
Okay.
share my screen.
Yeah, is there any way we can see the payment history?
Yeah, if you give me just a minute, I can log in on my computer.
Thank you.
I'm just not logged into tips right now. Okay, of course, there's a few different. It might take a couple of minutes.
The last payment that I remember making was $500. I think it was 2 months ago.
Okay. Okay, I'm in now. Let's see if I can get something up.
4 or 5.
Okay.
Okay, I see a last payment for October 14th, 2021.
And from 2015 till that payment, were there any payments that you see?
Yeah,
Other-
there was a nice amount of payments. There was payments made.
And has it been divided between principal, penalty, and interest?
Yes. Yes, they did flow across the stream, yes.
Thank you.
Is the board ready to go back?
I am.
Yes.
I am
Yes.
as well.
I am as well.
If everyone can just hold tight, the board is going to go into the virtual breakout room and they'll be back with the decision. Hi, everybody. I'm just waiting for Nancy. There she is to get back in. Nancy, everyone's in. You can take it away. You're on mute.
Okay. Good afternoon. The board has reached a decision. It's our decision to abate 100% of the interest and 100% of the penalty and ask for payment arrangements to be made within 60 days. I would indicate here that you'll receive a letter from the board that spells out our decision. Both sides do have the right to appeal to the Court of Common Pleas within 30 days of the date of our letter. but I'll assume for the moment that neither side is going to object. And in that case, you would have 60 days from that point to enter into payment arrangements. And it's important that you do that in a timely way, and that to the best of your ability, you maintain that agreement, or it would be negated, and anything that remains on the record would come back as part of the outstanding amount. Any questions about the decision we've reached?
Thank you very much, and I will do that immediately. Thank you.
Okay, thank you. You'll get the letter from us within a week or two. We've had slowdowns with the mail as with every other thing, so I can't give you an exact time period, but as the actual count goes from that point, but the sooner a determination is made about whether you're going to appeal or whether the city's going to appeal, the sooner the wheels can be in motion to get an agreement in place if that becomes the decision. Thank you for coming in today.
Thank you.
George Matthews, I concur the decision.
Oh, yes, that's right. Thank you for my fellow board member speaking up to get the concurrence on the record.
Ryan Boyer, I concur.
Paula Weiss, I concur.
Dominic Ward, I concur.
And of course, Nancy Camerdiner, I read that into the record in the first place, so I concur as well. Thank you for my reminder. And thank you for coming in.
All right. Thank you.
Next case will be number 4. No, I'm sorry. Yes. 4.
4.
Yes.
Yes, number 4 is a virtual hearing, and this is Cedar South, Philadelphia. Last 4 digits of the docket 9469. The property address is 2301 Oregon Avenue. Is the petitioner on the call?
We are David Schneider from the law firm Archer and Griner on behalf of Cedar South.
And do you have the petitioner from Cedar South with us?
I don't. I submitted the documents. I believe the attorney for the school district is here. Or not the school district, the city.
Lawrence Rillo for the city of Philadelphia. Mr. Schneider and I actually spoke right before this hearing, and there are a few things outstanding on this. So we're going to be requesting a 60-day continuance in front of the full board.
How many days was that, 60?
60, please.
Mm-hmm. Do you concur in that request, Mr. Schneider?
I do.
Okay. In terms of, I guess really I could ask openly with the board, do you have any objections to a continuance on this matter?
Has this been continued before?
I was just about to say, this is the first listing for this matter before the board.
I have no objections to a continuance, Nancy.
Ryan Boyer has no objections.
Dominic Ward has no objections as well.
No objections from my side, George.
Okay, thank you, and I would concur. So basically what we will do is mark this matter as continued. We'll get a scheduled date. It'll probably be a little further out than the 60 days because of our schedule timing, but I would ask that if you do reach any agreement between now and when we would be scheduling that, or when the date that is scheduled for it, that you let us know so that we remove it from our docket. Quite often in matters like this, once the parties get together to discuss it, a decision is reached that is equitable for both sides, and we don't need to handle it here. So we would appreciate your timely removal if indeed that happens.
We certainly will.
Thank you for coming with us today, and look forward to, we actually look forward to hearing that you've reached an amicable decision that that both parties are happy with.
Thank you. Thank you to the board.
Mr.
Okay,
Schneider,
thank you.
next time, if you guys are going to request a continuance, we could have taken you first. So next time, just let me know. We'll change the order of things.
Yeah,
Okay.
we had a discussion just last night. Apologize.
Okay, not a problem. Just heads up for next time.
Thank you.
Thanks, everyone.
Yeah, quite often coming to those deadlines of a hearing date really bring things together.
Yes. We'll get it resolved and let you know.
Okay, thank you very much.
Thank you.
Okay, the next item on our agenda, if I'm not mistaken, is item number 1. And that is for Hattie Ruth Thelman, last four digits of the docket. Having trouble reading this in the light I have here. It's 9978. Who has this matter? Let me ask, is the petitioner available or present?
Good afternoon, Kate Dugan from Community Legal Services on behalf of Ms. Thelman, and Ms. Thelman is here on the phone. It's that phone number that you see having called.
Okay, fine, thank you. Ms. Thelman, please identify yourself for the record.
Ms. Thelman, please unmute yourself. That may be the problem.
I'm going to text them just so they know, and in case there are any technical problems.
Uh-oh.
Oh no.
Yep, they just fell off.
Ms. Dugan, can you call her?
I'm texting her. I'm texting her right now. My guess is in trying to unmute herself, she might have gotten disconnected.
Yes. Nancy, why don't you ask about this? Nancy,
What? I'm sorry.
perhaps we can introduce the city attorney.
Okay. Who has this matter for the city?
Good afternoon, Adriana Gonzalez on behalf of the city.
And so we've already sworn in March, so do you have anything to add here?
Yes, I do have another witness,
Okay.
Mary Gemmett.
Who's the other witness?
She was.
She's here. She's here.
Yes.
Miss Gennett.
Mary Gemmett.
I'm muted. Yes, sorry.
Please identify yourself for the record.
My name is Mary Jeanette. I work in the audit department.
Do you swear or affirm to tell the truth with everything that comes before the board?
I do.
Okay, thank you. Are
looks
we
like
still
the-
waiting to get the petitioner on the phone or?
She's back in, and I've texted her to try to come off mute if she's able.
Yeah.
Is she off mute?
No, she's still on mute.
I can't
she's in the room.
see her in my display, so
I can see that she's still on mute. She's on the phone, so I'm not sure what she's looking at. It's probably different than our computer screens.
Is it possible for counsel for the petitioner to at least begin with explaining what their case is, and then when she's able to actually add it, she can testify?
We can certainly begin like that, yeah.
Okay,
can we
and
get the
if
numbers?
we're not doing that, we need to get the numbers for the record from the city.
Sure. The account as it stands today, and I will share my screen in just one moment. The account as it stands today, principal is only there's a credit on principal for tax year 2022 of $629.91.
And there's nothing else that's due?
No, nothing else is due. I believe Miss Dugan will, and I can clear that up.
Okay, because I was going to say, what we had on the petition was significantly higher than that and covered more years. So that's why I was asking.
It was. What happened was the petitioner's HELOC lender noticed that the taxes were due. And unfortunately, because of the delays in this case, they have since advanced the funds and are going to turn around and demand them from the petitioner. So the case is still ripe, except for the solution would be to create a credit, which would then go to the HELOC lender, as opposed to undoing a charge.
So how many years did the HELOC lender pay ahead, so we understood how much percentage?
Right, so the HELOC paid the 2014 through 2019 amounts in dispute, and they also paid 2020, 2021, and 2022, which are not in dispute. And I do have a breakdown for the board of what amounts we would be requesting a credit for.
So is this a credit situation, or will you be requesting a refund?
Well, I think technically the solution would be for the system to create a credit, and then for the HELOC lender to request a refund of that credit. Although if there's another way to coordinate that, we would be open to whichever way works best. But that's how we have found historically for this to work. And I do believe the petitioner has been able to come off mute, Madam Board Chair. So,
and if we could have the petitioner identify herself for the record.
She's still on mute.
No, she's still on mute. I think she thinks she's off mute.
Can you put your phone on speaker, Ms. Dugan? Perhaps that might be the easiest way for us to hear from her.
So she's not on the phone with me. Yeah.
Well, my only suggestion is that we tell her to get off of this hearing. She calls you and then you put your phone on speaker. If she cannot figure out how to unmute the phone.
I do not necessarily anticipate having to call her. So perhaps if there's no objection, we could proceed with the hearing and then deal with that as needed.
And she agrees that you can represent her in this matter without having her make her personal information known?
Yes, and I can, I'm confirming through text message that she's in and she's listening and she's gonna still try to come off mute.
Okay.
The city does have a few questions for the petitioner. Once the
Can you take your screen down? Unless, is there anyone on the board who still wants that screen information up?
We don't have.
You can take that down so that we can be more focused.
I just think we need the numbers that are.
We need Marge to read the numbers into the record so that way we know what that issue.
Okay, that was where we were headed before, yes.
Yes, and the city read them, so I didn't think there was any cause for me to read them. Hold on 1 second. It won't give me a screen, it's just giving me audio.
I just believe that we need to know what was at issue before it got paid off in order to examine whether or not relief should be granted.
Correct. I mean, I can read the numbers from 2014 on.
And tell us what years are outstanding.
Well, none of them are outstanding now, Nancy.
Okay, I thought there was something that was outstanding.
No, it's a credit for 2022. The loan company paid everything off on December 2021.
Okay, but so here's the thing. We're going to need the numbers for 14 through 19 that are at issue if we're going to go forth with trying to grant a credit and then subsequently they're going to request a refund. So whomever is able to give us those numbers, that would be great.
That's what I'm going to do.
And I'm confused as to whether this needs to be a refund posture now. I'm not sure what you're asking us to do.
Right.
That we have authority to do from the petition that's been filed.
Well, would the board prefer that we discuss the case and then perhaps figure out the solution? Would that be an easier order of operations?
It might be. If this is going to end up being a refund request by a separate party, then I'm not quite sure what we would be doing today that would be helpful. And maybe I have it wrong. Is that really where we're headed here?
So the party that would request the refund is not a party to this hearing right now.
Correct.
So that's what I think.
Not even.
Yep.
And this, I'm
We
sorry.
may not have any jurisdiction whatsoever here in that case.
And this is not even a refund petition that we're looking at. Or it hasn't gone through the refund process to get here.
Can I just get some additional information about when this was paid in regards to when the petition was filed?
So the appeal petition was filed in August of 2021. And we believe that the HELOC lender advanced the funds within the past 2 weeks. So it's a recent development. And in similar cases that have not gone to the board, we have found that the best way to do this would be to create the credit in those tax years and then work with the HELOC lender to get that money refunded to them because there's still taxes that the petitioners do.
Excuse me for a moment. You said that the petition was in 2020 or 2021. What I have on the information that was submitted to us was a petition dated June 13th of 2019.
Nancy, I think she's talking about the appeal to the board.
I am, thank you.
Okay, because that I was going back to what we had on the record. I'm sorry, my apologies for interrupting. Please continue.
So if the board would prefer, we can kind of explain where we are in the case and then perhaps come to the best solution. So this property, 2307 Grays Ferry, received the senior tax freeze starting in 2014. In 2019, the city conducted an audit in which it removed the property from the freeze. We do not contest the results of the audit, and we agree that it's appropriate that the property should not receive the freeze from tax years 2020 and on, because Hattie Thelman does not live in the property. However, the city went beyond its authority under the Philadelphia Code to go back in time and impose retroactive principal, interest, and penalties. Because under section 19-2906 of the Philadelphia Code, there is a requirement that the city find an intentionally false statement in order to do any of that. So we would oppose the city's retroactive imposition of all of those charges to make it look like the freeze had never been imposed, because Hattie Thelman received those bills, she paid those bills timely and in full. And it was only in 2019 that the city went back and added all those charges in. So since the code does not allow the city to do that, it's our position that all the city could do was go through the audit process and remove the property going forward. And I do have a rough calculation of what that number is, because I understand that some of the amounts advanced by the HELOC lender are amounts that were appropriately billed to the family.
I just have a question for you. You're saying that originally your client did pay 2014 to 19?
No, she did pay 2014 to 19 in full. So what happened was the bills she received from 2014 through 2019 reflected the senior freeze. Ms. Thelman maintains that she never applied for the freeze. She never signed a statement. The city, even after a year of asking for a copy of the application, the city has been unable to produce the application so we can confront Hattie Thelman with it. It's our position that whoever put her in the freeze, whether well-intentioned or not, there is no intentionally false statement on the part of the taxpayer, meaning all the city has the authority to do is remove her from the freeze going forward. But she did pay the freeze bills, like the bills that she received in the mail, she paid timely and in full every single year.
Thank you.
So Ms. Dugan, what are you looking for here now? You want a refund, or you want a credit?
Well, so unfortunately, because of the delays in the city not giving us the application, and then there was a scheduling mistake with the TRB, there is a HELOC, a home equity line of credit loan against this property. The lender stepped in and advanced the funds, and now has put this whole thing has put the Thelman the Thelman family in imminent risk of a mortgage foreclosure because of the almost $40,000 they advanced. So what we would request is the tax review board create a credit for those retroactive charges only. My breakdown shows that it's about $15,800, although I think a little bit of interest has probably accrued since I made those calculations. Once that credit is showing, what we've done historically is that we've worked with the lender to request a refund of that credit. The money would then go to the lender, and the lender would not be demanding it from the client. It's maybe not the most efficient solution, but it's the one we've been able to make workable given how everybody's computers talk to each other.
Can I ask a clarifying question, please? Ryan Boyer, Tax Review Board member. So what you're saying in testimony is that the owners of the property paid the taxes in full. The city then did an audit and found that they didn't think that the property was eligible for the senior freeze, and subsequently charged them the interest and the penalty had the property not been on the senior freeze.
Correct. They went back in time to 2014 and added in not only the principal the difference between the freeze and the non-freeze principal and the interest and penalties. And to do any of that, the Philadelphia Code requires that there be an intentionally false statement. And despite months of asking the city, there is not an intentionally false statement. We do not know the circumstances under which this property was put into the freeze. I think that was the first year the freeze existed. It might have been an oversight. It might have been a mistake. But the code does not permit the city to go back in time and add those charges in retroactively, only going forward, which we do not dispute.
Ms. Dugan, what section of the code did you cite?
So it's section 19-2906, and that is the senior tax-free section. It's also the section that gives the tax board, the review board, the authority to review this case, even though there is no delinquency in the credit. Under 19-2907, this board may review any adverse final decision or determination of the department relating to a taxpayer's initial and continued eligibility. So it's only the initial. We're not disputing continued eligibility.
But you're saying she was not eligible.
So we have no position as to whether she was eligible starting in 2014. What we're saying is that once the city puts her in the program, they're certainly free to audit her. They could have audited her in 2015. They just didn't audit her until 2019. Once they audit, they have the power to remove, but they do not have the power to go back in time and create unpredictable, huge charges for a family that then puts them at the risk of the foreclosure. It's simply what the code allows.
Any other questions from board members?
No, I'd like to hear from Ms. Gonzalez.
Yes. So again, while Ms. Dugan says that the city's only recourse is would be because of an intentional false statement, we do have information that shows that there were numerous misrepresentations regarding the primary residence of Ms. Hattie Fellman throughout the time. Ms. Fellman had 2 separate homesteads. There was a rental license that was maintained on the 2307 Grace Ferry property throughout this time period. So it is difficult to state that the city never received a false statement regarding her residence at 2307 Grace Ferry Avenue. She was aware. It is abundantly clear that a homestead or a taxpayer or a senior tax freeze is something that is reserved for owner occupants, and we have an abundance of conflicting information showing that Miss Fellman was aware that 2307 was not her primary residence, and yet continued to receive the benefit of both with homestead and with senior tax freeze of claiming that it was her primary residence. And I have Miss Jeanette here to talk about the audit that was performed in 2017 that resulted in the homestead and then subsequently the senior tax freeze being removed.
I mean, I'd like to hear what Ms. Jeanette has to say.
Mm-hmm.
Would you please state your name for the court, Ms. Jeanette?
Mary Jeanette,
And what is your title?
Revenue Examiner,
How long have you worked for the Department of Revenue?
2 years.
And what are some of your job duties?
I perform various types of audits.
Was an audit ever performed on the account or accounts for a property owned by Hattie Fellman?
Yes, back in 2017, there was an homestead exemption audit performed on 2307 Grays Ferry Avenue.
Why was that audit initiated?
Routine audit. Sometimes when homeowners are receiving a homestead on 2 properties, an audit is performed to determine which property is their primary residence.
How did that audit proceed?
Letters were sent out to the taxpayer at both 2307 Grace Ferry and 1130 West Oxford Street. And then she responded with documentation that was requested in the letter.
Did you perform the audit yourself?
No, I did not.
Who did?
Marlena D'Alessandro?
Is Ms. D'Alessandro still employed with the Department of Revenue?
No, she is not.
What years did the audit relate to?
2014 to 2017.
What were the findings of the audit?
So according to documents that Hattie submitted, she submitted a Pennsylvania driver's license, which was issued August 3rd of 2015, and a PICO bill dated 7/26 of 2016. Both claim her permanent residence or domicile was 1130 West Oxford Street, not the 2307 Grace Ferry.
Why was it found that a homestead exemption for 2307 Grace Ferry Avenue was inappropriate?
Because you can only receive a homestead exemption on the property that you currently reside in. And by the documents that she submitted, she proved that she resided at the address located at 1130 West Oxford.
Does that mean that Hattie Thelman should not have been receiving a homestead exemption for 2307 Grace Ferry Avenue?
Yes, that is correct. A person can only receive a homestead exemption on the property in which they currently reside.
And if Ms. Thelman was ineligible for the homestead for 2307 Grace Ferry Avenue, would she also have been ineligible for other taxpayer assistance programs like LOOP, UPA, or the senior tax freeze for those years?
Yes, all the programs only represent for an individual's primary residence.
And through the audit, it was found. Was there any other information found in the audit that showed that this was not her primary residence?
Other than the documents that she submitted, no, I don't have any other information.
Okay, thank you very much.
Thank you.
Anything else from the city?
Yes, I would also, if I may share my screen, there is a rental license for 2307 Grace Ferry Avenue that was issued in 2003 and renewed in 2019 that clearly states that the property is not owner occupied. And I can, if I may, I can show this to the board.
Madam Board Member, I do have some questions for Ms. Gennett, either now or when the city is finished.
I was having trouble hearing what the city said. Were you finished with your comments from the city, Sand?
I was finished with my questioning of Ms. Jeanette. I was also going to put forth a rental license.
Oh, okay, but in terms of Ms. Gannett, you were finished with her?
Yes.
Okay, then if there are questions of her from either board members or from the petitioner, now would be the time.
The petitioner,
board
should we
members
do
have
cross
questions
first?
for Ms. Gannett. Let's go to that first.
The petitioner should do cross-examination first, and then we can ask questions after.
Okay, fine. Then if the petitioner would proceed with any questions that she has.
Hi, Ms. Gennett.
Hi, how are you?
Good. So this audit that you just discussed, the 2014 to 2017 audit that was done in 2017, that was for the homestead exemption, correct?
Correct.
And as a result of that, you removed the property from the homestead in 2017?
2017 and 2016, I believe it was removed. Let me double check.
But the action was taken in 2017.
I believe so, yes.
Correct. And then, but then you did not do the audit for the senior freeze until 2019, correct?
I have no record of the senior freeze audit.
Do you not perform senior freeze audits?
No, I do not.
Okay. Do you have any involvement with initial senior freeze applications?
I do not.
Do you have a copy of the application that Ms. Hattie Thelman submitted to get into the senior freeze for this property?
I do not.
The questions are outside the scope of my direct examination.
Go ahead, Dominique.
I'm not sure how we proceed
So-
here. I'm not an attorney, so I can't comment on that.
Well, I would note that if she's a city employee who is involved in tax programs, it would be within the scope of what I can ask if she has records relating to the city's authority to not only remove, but impose those retroactive penalties through the audit process.
we're not bound by strict rules of civil procedure as an administrative board. And this, if we deem it relevant, we can accept it for the value, the probative value that we determine it carries.
So Ms. Gennett, even though you are aware that Ms. Thelman submitted a license with that 1130 Oxford Street address, the audit for the senior freeze was not actually performed until 2019, to the best of your knowledge?
I know, I'm not sure when that audit was performed, as I had no ties to that audit.
I have some notes here if that can help. It says about the audit. The homestead audit.
Hold on, wait. Sorry, Mark. I don't mean to interrupt you. So counsel for the petitioner is cross-examining Mrs. Gennett. The city will have an opportunity to rehabilitate any answers that she gives when she speaks, if she calls on you again, or if she has any redirect of Ms. Gennett. But at this time, the only two people that need to be speaking are counsel or petitioner, Ms. Gennett, and if counsel for the city objects again to the line of questioning.
Thank you. So Ms. Gennett, to the best of your knowledge, what was the date that 2307 Grace Ferry was removed from the homestead?
I believe after the audit was done in 2017.
And you don't know anything about the audit in 2019 for the senior freeze?
I do not.
And you don't have any records about the initial 2014 application for the senior
I do
freeze?
not.
All right, thank you. That's all the questions I have for Ms. Gennett.
Okay. Anyone else from the board have questions of Ms. Gennett? I guess not. So is there anything else from, I'm not sure what the order here would be to, I guess, go back to the city. Or do we have any questions on other related matters from city board members?
Nancy, the city was still presenting its case. I think it's.
I couldn't hear what you said.
I said it's Ms. Gonzalez. The city was still presenting its case.
Okay. Well, that's okay. I kind of lost where we are.
Do you have any redirect for your witness, city?
Ms. Gennett, is it part of your employment to be involved in the audits of senior tax freezes?
It is not, no. I'm only in charge of refund audits, homestead audits, and worker misclassification audits.
Thank you. Ms. Dillon indicated previously that she had information to show us regarding the senior tax freeze, and I believe that information is contained within tips, within the notes. If Ms. Dillon could please pull it up for the board for them to see. I believe there is a note.
Okay, so I have all of the notes that were asked for from 2014's denial to 2019's denial. I'm going to share the screen now and you tell me where to go.
So there is a note from June 17, 2015.
Sorry, Ms. Gonzalez, can you
Will we be seeing this?
And can you share the screen?
Can you see that?
No.
We can't see it.
How about now?
Now is okay.
It's saying that it's sharing it.
We can see it now, Marge.
Okay. So direct me what you need me to do.
So as far as the city's records of the senior tax freeze, in 2015, we also have record that we asked for verification of the senior tax freeze from for 2307 Grace Ferry Avenue from Miss Hattie Thelman and received no response. And then there is another note in December of 2015, 12/8 for 2015.
Okay, 1 minute.
That the taxpayer was brought in the income information regarding the senior tax freeze and was put back on the senior tax freeze for years 2014 through 2015, indicating that at the time, Miss Hattie Thelman was aware that she was receiving the benefit for the senior tax freeze, while at the same time having a primary residence of 1130. While her primary residence was not 2307 Grace Ferry Avenue. Those are the remainder of those. That's the end of the notes and tips. I would also like to show for the board's benefit. The rental license that was applied for in 2003 and maintained throughout from 2003 through 2019, that also states that 2307 Grace Ferry Avenue was not owner occupied, if I may.
Anything else from the city or any questions of the city from the board?
I have a question. So based on these notes in this system, tips, do you have any letters or anything like that that was sent to the petitioner at any time regarding the senior tax freeze program?
We do not have the letters.
So you only have these notes that are in the system, evidencing her coming in. Okay.
If Ms. Dillon would allow me to share the screen, I can share the rental license. Also, rental license applied for by the petitioner, stating that the property is not owner occupied and was for the purpose of renting.
You should be able to share your screen now. I stopped Marge.
So as you can see, this is a rental license from the city showing that there is a 1 unit at 20.
I can barely hear you.
Sorry.
Can you get closer to your mic?
Is this any better?
A little better, yes.
Thank you.
So as you can see, this is a rental license that is now inactive, but was only inactive as of April 29th, 2020. That was initially issued on April 10th, 2003 and renewed March 6, 2019. That states the property is not owner occupied as well. So there is an abundance of evidence that at very least there were inconsistent statements regarding Ms. Thelman's residence throughout the time that she received and was knowingly receiving the senior tax freeze benefit for 2307 Grace Ferry Avenue. I have nothing further. And because those statements were intentional, the city has the right to rebill for the periods of time when she received a benefit that is solely meant for owners that occupy their properties. Throughout this time, it was clear that there were numerous inconsistencies that, given the totality of the circumstances, cannot be termed to all be accidental false statements. Given the totality of the circumstances, not all of these conflicting statements can be interpreted as unintentional. Therefore, the city has the right to rebill for the years in question. Thank you.
Nancy, does the petitioner have anything else left to say?
Yes, if I could respond. Thank you. So I have been asking the city for over 8 months for proof of any false statement upon which the senior freeze was granted in 2014. I have received nothing. I am a little blindsided by all this stuff that Ms. Gonzalez is showing you now, because I've been asking almost annoyingly frequently for it for over 8 months. However, the existence of a rental license that went into effect in 2003 has no bearing on, unless that was the basis upon which the senior freeze was granted, and I cannot imagine that it was, has no bearing on this case. I was only able to look at the screen as you were. It looks like it was issued in 2003 and renewed in 2019. It could very well have lapsed since then. I don't know that the city reviewed that. Maybe the city should have looked at that in 2014 when they granted it. And everything in between then. Every statement that Ms. Thelman made after 2014, perhaps that was a basis to remove her from the program, which the city eventually did. However, once the city granted the senior freeze exemption, which was started in 2014, unless there is a showing of an intentionally false statement, the basis of which was the approval for the freeze, not just random intentionally false statement out there in the world, but an intentionally false statement that was the basis for the approval, all the city can do is remove from the program. They cannot go back in time. And perhaps the city should have audited this in 2014, 2015, 2016, 2017, but they didn't. They didn't audit until 2019. And still, the city has not produced the intentionally false statement that was the basis for the approval. The only year we should be talking about is 2014. And what Hattie Thelman signed in 2014 that was intentionally false. Having not seen any of that, the code does not permit the city to go back in time and retroactively add those charges, although we would agree that for tax years 2020 and forward, this property should not receive the freeze.
Nancy, could we talk to my fellow board members? Could we have a discussion about this?
I do have a brief response to Ms. Dugan's allegations that I never shared any of this information with her. I did share the entirety of the homestead file, which includes a statement that says there is a rental license on the property. Also, the rental license, the Eclipse system, is publicly available.
And so our response would be the rental license is completely irrelevant to this case. And it was issued in 2003 when I don't know what this property was doing in 2003.
Well,
Additionally,
I have a question for the city. In normal practice, if someone is being considered for a senior freeze, do they ask if they have any rental licenses or things like that, or is that just not part of the conversation?
so
Because
a
I can think that a petitioner might not have any idea that that is something that would be a problem.
So a rental license in and of itself. So if we think about a duplex or possibly a property that has more than one room, if you had 5 rooms in your home and you wanted to rent one of them out, but it's still your primary residence, you would still need a rental license. So a rental license in and of itself is not a complete bar to a program for an owner occupant. However, a rental license that indicates that, and also the senior tax freeze application doesn't necessarily immediately ask, do you have a rental license? It asks, is this your primary residence? And do you meet the income requirements? And do you meet the age requirements? So that's not necessarily, I could understand someone saying they wouldn't think to produce their rental license. However, if your rental license states that this is not your primary residence, affirming on an application, affirming through reapplying for the program, affirming through bringing in documentation to continue to receive the benefit of the program, while knowingly not having this as your primary residence is the basis for the approval.
Do you have evidence that the city asked if this was the primary residence at the time that it went in? Do you have anything that would verify that?
That the city
Is that a part of a questionnaire, for example?
When this particular senior tax freeze was removed, no, because the removal was as a result of realizing there were 2 homesteads in Ms. Thelman's name for 2 separate properties.
Okay, thank you. Any other questions for the city before we step aside?
Okay.
I just have one more question just to make sure. Ms. Dugan, is there any way we can get testimony from your client?
Unfortunately, she cannot seem to take herself off mute, but I can represent, she has indicated she's okay with me going forward. I actually don't know that there's anything useful she would say other than, she never applied for this. But
can she confirm or deny that she was in the offices of the Revenue Department in 2015?
I'm not sure her memory would go back that far, to be honest with you. I think the only important thing here is when she was placed into the freeze, we don't know the circumstances. We don't have a copy of that application. A tips note does not mean that she signed anything or affirmed anything. It means that somebody in the city perhaps made a mistake and would be within their rights. They could have denied her in 2014 had they seen that rental license. They could have removed her in 2015. But absent a showing of a false statement, as opposed to a mistake on the part of a city employee, all the city has the authority to do under the code is remove going forward, which we don't dispute.
Thank you.
Okay.
That's all I have.
Oh, are you good, Dominique? Okay. At this time, the board is going to go into the breakout room. Woody will be right back. All right, Nancy, Paula, Dominique, George, and Ryan, everyone is back.
And is it Paula or is it Dominique who's going to give our decision?
Dominique.
Oh, hi. Hello, everyone. Tax review, excuse me, tongue tie. The tax review board has met and we reviewed all of the testimony that we heard today. Thank you, both city and council for the petitioner. And we've come to this conclusion. This tax review board does have jurisdiction to hear and adjudicate this matter based on code section 19-2907. And with that, we will give a ruling on this petition. Based on the evidence presented today, we will grant this petition for year 2014. However, we will deny the petition for years 2015, 2016, 2017, 2018, and 2019 as it pertains to principal with a full abatement of interest and penalty for those respective years of 2015 through 19. And that is based on the business record that was given through testimony of the tips, where it shows that the petitioner did come in 2014 or the year of 2015 and verify her income verification and reapply for the program going forward until she was removed subsequently in 2019, or rather 2020. Do you have any questions from the petitioner or from the city about the ruling?
Ryan Boyer, I concur with the ruling.
Paula Weiss.
Yeah, I was just going to say that you'll get a letter from us that spells out this decision. Both sides have the right to appeal to the Court of Common Pleas within 30 days of the date of that letter. Assuming no one appeals, then this decision would be implemented after the 30-day period.
And just as a technical matter, with this, so since there's no payment to be made as the HELOC has already advanced the funds, would we use this letter to then generate a refund petition to the city?
So if this is not appealed, what's going to happen is that the bill will be recalibrated and subsequently a credit will be generated on the account for that. And
so in essence, the tax review board is directing the Department of Revenue to issue a credit.
Got it. Thank you very much.
This is not in the refund posture.
Thank you very much for joining us. And this portion of the hearings are adjourned. We do have two other items that were on the agenda. Has anyone shown up for them?
No, however, I just received something from one of the people who work in my office. Ms. Nelson requested a continuance back on January 26th. Unfortunately, that was not given to me until just now. It looks to me like there's only been one other continuance on the matter. So, and actually that was at the master level. So this is the first hearing before the board.
And that is item number 3 on the agenda?
Correct.
And the docket number on that is, if I could read it here, it is 4705. And so do the board members concur with a continuance on that matter to approve the continuance?
Do you have anybody from the city here that is opposing counsel for that matter?
It's a GRB case, and I don't think there's anybody here from GRB.
Okay.
Ryan Boyer, I concur.
Paula Weiss, I concur.
Dominique Ward, I concur.
Nancy Camarena, I concur. Okay, and have we heard from anyone for item number 5?
One moment, I just want to go back out and check and make sure that nobody's in the waiting room.
Okay, just to complete on that item number, it's the docket ending in 8787, but we'll see in a moment if anyone's here.
No, no one is here.
Does the city have any information concerning this matter?
No, the city does not. And according to tips, this has been continued, it looks like 2 or 3 times before. So I would ask for a denial of this petition.
This case was also marked no further continuances.
Okay, so basically, we're denying it for failure to appear and are not going to honor any further requests for hearings. Do the board members concur in that?
Ryan Boyer, I concur.
Paula Weiss, I concur.
Dominique Ward, I concur.
I concur.
And I agree as well. So we have all agreed that we're denying this petition for failure to appear, and there are no further hearings to be granted. Unless there are some other items to come up that are not on today's agenda. If you have any, speak up. Otherwise, this hearing is adjourned.
Thank you, everyone. Have a wonderful
Here,
weekend.
everybody.
Bye.
Thank you
Thank
all.
you. Have a nice day.
Thank you.